I'm just glad to be here. How you doing, Miss Goldsmith? You got sunburn. It was a regular damage as far as. Hey, I want to get, I think you were here last Tuesday. I want to get it done. I want to get the transcript. Thank you.
All right, the second session of the Hamilton County Police Court is now in session. We come to the across the line. Please be seated, remain quiet, turn off employees cell phones. Good morning.
Good morning.
I never really goes on the way down, and can we do something else in the meantime? What is that?
I'm James Crossrunner.
Oh, thank you.
All right, this is the matter of State of Ohio versus James Cross, case number B 22058080. Mr. Cross is present in the courtroom with his attorney, Mr. Tim McKenna, and Ms. Jackie Stakoviak is present on behalf of the State of Ohio. I don't know why it still says Caitlin Mock. That's a case that has to be, this is the case of Stakoviak that the name needs to be put on there.
Yes.
Okay. Was there someone in your office, did they do that?
Yes.
Make sure that.
Apparently there's a whole process, but yes.
Okay. All right, excellent. All right, Mr. McKenna, this is a clear trial setting. We have a trial date, looks like set on April 24th. Do you have discovery yet?
Not, Your Honor, I filed for discovery in November and waiting. I had asked the office a couple of times whether they had people leave. I was just informed I could get it this week.
As in 2 months ago? State?
Your Honor, I can only speak to the contact that I had with Mr. McKenna. And he did send me a text message, I believe it was last week. I asked him to send me an email because I forgot about the text message, and he did, and then I forgot about the email. So from last week to now, that is my mistake. I do not know. There are no notes in the file or explanations to why discovery has not been provided up until I took over the case. But I did tell Mr. McKenna I would get him everything by the end of this week.
Mr. McKenna, if you don't by Friday, file motions to compel, and I will grant it.
Thank you.
All right, so let's go ahead and set this matter over for another setting. Mr. McKenna, you want to do it in about 30 days or so?
I'll be fine, Your Honor.
All right, let's continue about 30 days or so.
February 21st.
That works.
All right, February 21st, 2023, 9 a.m. Is time waiting to April 24th?
Yes, Your Honor, my client's out. He's cooperative, keeps in touch with me.
Okay, thank you. Now, I know that Mr. James Cross and I have the same last name, but to my understanding, there's no relation. Is that your understanding?
Yes, ma'am.
All right. So, all right, we will go ahead and continue this because discovery is outstanding, and then, Mr. McKenna, if you don't receive discovery by Friday, file a motion to compel.
Thank you.
All right, thank you very much. Anything else?
Okay,
All right, State?
No, Your
All
Honor.
right, thank you. Judge, you want to sit up? Not yet. Ms. Bolden.
Mr. Haas. Mr. Haas. Mr. Haas.
Okay,
We have a last. Oh.
Thank you.
Mr. Evans needs to get here. And Mr. Fire needs to get here. He was. Okay. Mr. Fire and Mr. Evans, that's it.
Then.
Yes, they are.
So I think in your favorite print, the Spalding judgment entry. Yes. Well, maybe we don't have that, we're waiting on probation to do it.
Yeah, we taken, uniform for last time and did.
Okay, so, the probation officer recommended that she cut you loose and they can go to Clermont County, not cut you loose, but let you go to Clermont County. And then, when you release there, go to ADAP. Have you done any treatment while you're here? Did Judge Bender make you eligible for treatment? Okay, well, that's what I Judge Stewart, the probation officer. I can't speak to that, I don't know, I mean, I just don't know. I hope so, but I can't promise that.
All right, this is a matter of State of Ohio versus Brittany Boland, case number B 22-01192. Ms. Boland is present in the courtroom with her attorney, Mr. John Dameron, Ms. Jackie Sekoyak for the State of Ohio. This matter is on for resentencing. Mr. Dameron, did you receive a report, a one-page report from Hamilton County Probation Officer Brandon Adams?
I did, thank you.
All right, and Mrs. Koliak, do you know what's going on?
I do know.
Oh, okay. All right, so anything you want to say before we sentence?
Your Honor, we just asked you to follow the probation officer's recommendation. As you know, she had reporter for Paramount County issue, which is preventing her from going to the ADAP program. And probation officer recommended respectfully, that we modify her probation, for her immediate release so that she can go to Paramount, so that to modify the sentence so she can go to Paramount County, and then upon release from Paramount County, go to ADAP, and that's what we want to do.
All right, Steve,
The first report, your honor.
Ms. Bowling, anything you want to say? All right. Well, I'm sorry you're still here. I didn't expect for you to still be here. That is not my intention for you to be in the Justice Center, but you have a Paramount County warrant, which, you know, we have no control over. So what I am going to do is I am going to follow the recommendation of the probation department and the request of your attorney. What I sentenced you to before, I'm going to re-sentence you to the same thing, which is restore your community control, add 1 year, costs and fines will be remitted. But this time, I'm going to sentence you to indicate that you shall report immediately to probation upon release from Paramount County so that you can be processed and transported to ADAPT for that being a condition of community control. So I'm not terminating that condition, I'm just putting it on hold at this point until after you take care of Paramount County. Because with the holder, you can't go to ADAPT. I really think you need that. So I'm hoping that whatever your situation in Paramount County is, they will see that we are trying to get you treatment, and we'll maybe order something that is aligned with what I ordered you to do. So, if you violate the conditions of community control, I will not hesitate to sentence you to a term of up to 36 months in the Ohio Department of Corrections. You understand? All right, so today, I'm going to order that you be released to whatever the holder is, so you can take care of that and then come back. But I need you to report, if you get released from Paramount County, I need you to report to probation immediately. All right, otherwise it's going to be a violation of your community control. Okay? Any questions? All right. Anything else, counsel?
No, Your Honor.
All right, Steve. Thank you. This is the hearing. And
That's it.
He was here.
Okay. Can you tell me if he's following? He just.
So defendant's name?
Lawson was the one that was murdered.
Okay, who is charged with it? Is it
Wesley
Wesley?
Moody.
No, I'm not the prosecutor. The
Who's
prosecutor,
already confined her?
she has not been here yet. The case isn't set until 10, so she'll probably be here in about 15 minutes. Okay.
over here in the academy.
Yep.
Yes. Yeah. I can have that, yes, thank you.
Hi, how are you? Oh, thank you. I'm sorry. Yeah. Thank you so much. I'm sorry. Yeah. Oh. Yeah, that's not great. Thank you.
Mr. McCluskey, do you, someone on the docket this morning?
I do, Your Honor, this is Fields.
All right, is he, he's here?
To the news.
All right.
Is that okay? Okay.
Are we ready on, Fields?
He's reviewing some paperwork right now.
All right.
If family of Wilmer Diaz, here his mother, here his mother. Would you like to sell that? Yes.
Mr. Cogan, you are preparing for a trial.
Yes.
No, that's period. That's in case of trial.
The only one I'm not sure about is Shannon Warmack with
Oh, okay.
Terry Wallace. But everything else should be taken care of.
Oh, I was just going to tell you, you could sit at the council table while you can speak if you wanted to. But, okay. All right, this is the matter of State of Ohio versus Michael Fields, case number B 22-03189. Mr. Fields is present in the courtroom with his attorney, Mr. Hugh McCluskey Jr., and Ms. Jackie Stupoliak is present for the State of Ohio. This matter is set for a jury trial today, but it's my understanding the parties have reached agreement and, agreement on the resolution. And is that accurate, Mr. McCluskey?
It is, Your Honor.
Is that your understanding too today, Mr. Fields? All right. Are you the Michael Fields named in this indictment?
Yes,
How old are you?
45,
45?
45.
And how far did you go to school, Mr. Fields?
I got a GED.
So you're able to read and write the English language well?
I'm sorry.
You're able to read, are you able to read and write the English language well?
Yes,
Are you a US citizen?
yes,
Have you ever served in the military?
no,
I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize your attorney's signature here. Is this your signature above, Mr. Fields?
yes, ma'am.
All right. This is an acknowledgement by you that you understand you have a constitutional right to have a trial today, But when you sign this form, you're indicating to the court, I understand that, but I'm waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, sir.
Did you sign this form after consulting with your attorney about your constitutional right to a trial?
Yes.
Do you have any questions about this form?
No.
Do you have any questions about your constitutional right to a trial?
No.
I also have in my hand a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize the prosecutor's signature here, your attorney's signature here, but up here, sir, where it says signature of defendant, is that your signature?
Yes, Your Honor.
Madam Prosecutor, would you please put on the record the party's expectation regarding this plea?
Yes, Your Honor, Mr. Fields is charged in a single count indictment, this is F5 aggravated possession of drug charge. It's my understanding that he is going to be entering a plea of guilty as charged to that single count. There is nothing to dismiss. There is no agreement as to sentence among the parties.
All right, thank you. Is that accurate, Mr. McCluskey?
Yes, Judge.
Is that your understanding too, Mr. Fields?
Yes, Your Honor.
Sir, are you under the influence of any medications, alcohol, or drugs today? Do you now, or have you ever suffered with or even been diagnosed with any type of mental health difficulties?
Yes.
Can you tell me a little bit about that? Can you tell me a little bit about that? What were you diagnosed with and when?
Very much schizophrenia, as well as bipolar.
Okay,
He received Social Security disability for bipolar and schizophrenia.
all right. And so have you been prescribed medication to manage those conditions?
I'm starting dealing with tomorrow and I've been on the
All right. As you stand here today, do you understand everything that is going on? All right. If at any time you don't understand something, please stop, and I'll stop and ask your lawyer or ask me, and we will do our best to make it clear for you. Understand? All right. Are you presently under any type of probation or community control supervision in this or any other state? Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all if you enter into this guilty plea today?
No.
Are you making this plea of your own free will?
Yes.
Now, it's my understanding from what the prosecutor just said, you are expected to enter a guilty plea as charged to the single count indictment of aggravated possession of drugs, the felony of the 5th degree. Is that what you talked with your attorney about before this hearing?
Yes.
Did you have an opportunity to review and discuss this 3-page plea form with your attorney before this hearing?
Yes.
Do you understand what it says? Do you have any questions about it? Do you have any questions about it?
No.
All right. Sir, do you believe you've had enough time to fully consult with your attorney about your entire case before this morning? Has your lawyer answered all of your questions to your satisfaction? Have you had an opportunity to review and or discuss the evidence that the state has against you with Mr. McCluskey? Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge?
It has been turned over, Your Honor.
All right. And Mr. McCluskey, you acknowledge to the same?
Yes, Your Honor.
Mr. Fields, are you satisfied with your lawyer?
Yes.
Now, sir, do you understand this charge of aggravated possession of drugs that's been you've been charged with? Do you understand that if you plead guilty, you are giving or waiving, when you plead guilty, you are making a complete admission that you committed the allegations contained in the indictment. Do you understand?
Yes.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? And this being a felony of the 5th degree, do you understand that you're facing between 6 and 12 months in prison and up to a maximum fine of $2,500? Do you understand? Do you understand that if I sentence you to prison, upon your release from prison, you could be on close release control for up to 2 years? Do you understand that?
Yes.
Mr. McCluskey, you filled this out correctly, but in the last column, you put up to 2 years. which is what I just informed Mr. Fields about. And can you show him where you're doing that? All right, did you see your attorney add that? I wanted to make sure it's clear for the record because you've already signed your name to it, so any additions, I want to make sure that you are aware. And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that? Are you on post-release control right now?
I'm currently with Butler County.
From Butler County? All right, is that probation? Or-
No, it's a parole thing. She knows about, she heard already discussed all this. She sees, I see her once a week, every week.
Okay. Well, okay.
No, that's not.
All right, so are you on post-release control?
Yes.
All right. Well, do you understand that if you are on post-release control and you committed a felony offense while on post-release control, that in addition to being sentenced for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. You understand? All right. But also, since this is a felony of the 5th degree, community control or probation is a possibility. You understand that I could place you on community control for up to 5 years instead of sending you to prison. You understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court. And if you are placed on community control and you violate the conditions of community control, then you'd be brought back before me for a more restrictive sanction, which could include the imposition of a whole host of penalties. But the most severe penalty could be imposition of prison time up to 12 months that I previously discussed with you. You understand? Do you have any questions so far, sir? All right. Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand that? Mr. Fields, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial either to the court or to a jury of 12 persons? Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself? Do you understand each of these rights I explained them? Do you have any questions about your constitutional rights? Do you have any questions about anything we've discussed today? All right. Mr. Fields, knowing everything the court has discussed with you this morning, do you still wish to enter a guilty plea as charged to the single count indictment of aggravated possession of drugs of felony of the 5th degree? Counsel, is there anything further before I accept the plea?
No, Your Honor.
Make your statement facts.
Yes, Your Honor, this occurred on or about July 3rd, 2022, Hamilton County, Ohio. Defendant Michael Fields, knowingly obtained, possessed, or used a Schedule II controlled substance, to wit methamphetamine, in an amount less than the bulk amount.
All right. Anything on those facts, counsel?
No, Your Honor.
All right. Mr. Fields, did you hear what the prosecutor said you did? Did you hear what she said you did?
I heard what she said.
All right. Is it all true?
Yes.
All right. What is your plea to count 1, aggravated possession of drugs, a felony of the 5th degree? Let the record reflect that Mr. Michael Fields is present in court with his attorney, Mr. Hugh McCluskey. and that Mr. Fields was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Fields understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. Michael Fields guilty as to count 1, aggravated possession of drugs, a felony of the 5th degree, in violation of Revised Code 2925.11, subsection A. Counsel, is there any reason why a sentence should not be entered today?
There is no reason to.
All right, are you waiving PSI?
Yes, please.
All right, what would you like to say on behalf of Mr. Fields?
So, on behalf of Mr. Fields, he would like you to know that he is 45 years of age and a lifelong resident of this community. He obtained his GED from Hamilton High School. Judge, as he told you, he is diagnosed with bipolar impairment and schizophrenia, for which he receives Social Security disability. He attends Brightview treatment 3 times a week and sees his psychiatrist 4 times a week. In reviewing the body camera footage of this encounter, Judge, he was polite and overly cooperative with the police. Based on that, I'm asking you to place him on community control.
All right, thank you very much. State.
Defer to the court, Your Honor.
All right, Mr. Fields, is there anything you'd like to say, sir?
Just a foolish mistake, given to what I did. Going through a lot of life, seeing a psychiatrist just coming in and just was coming home for getting out of prison. I was so confused. I just went back to what I knew originally, but now I find a better way out. I go get home here every 4 days a week, and I'm finally getting on track where I need to be.
All right, so 4 days a week you're going to Brightview and seeing your
So 3 days a week to Brightview, and 4 days a week I go to my psychiatrist,
I see.
which is, my psychiatrist is at Brightview, my psychologist is at Brightview.
All right, and at Brightview, what do you go there for?
So
What do you go to Brightview for?
it's for drug counseling, it's, just to talk, get things off my chest, just
Good luck.
All right, how long have you been out of prison?
How long have I been there?
Been out,
Oh, since November of 2021.
I see. All right. Well, it sounds like you've taken some steps to address your issues. I'm glad to know that. So, the court has considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish the purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I have recently calculated this sentence to achieve the 2 overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors set forth in Revised Code 2929.12. Accordingly, Mr. Fields, I'm going to order that you shall continue your outpatient drug treatment with Brightview. What's the formal name of it? Brightview?
It's Brightview.
Just right there.
Brightview Services. All right, we'll look it up, I'll look the formal name and the entry. Continue with outpatient drug treatment with Brightview Services and your mental health counseling with your psychiatrist. I'm not gonna order probation, because probation, all we're gonna do is do the same thing. So, and then I'm gonna, are you working? Oh, you're on Social Security, right, all right. Costs and fines remitted. So I'm cutting you a break today.
She's cutting you a break.
Yeah, yes, you are.
And I'm not putting you on probation. I want you to continue with the treatment plan that you already have in place, because it's a lot. But, I'm gonna remit the court costs and fines, but if I see you back here on a drug charge, trust me, I'm not gonna be as gracious. Do you understand?
Yes, ma'am.
All right. You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand? All right. Anything else, counsel?
No, Your Honor, thank you.
State?
No, Your
All
Honor.
right, I wish you well. Ms. Mr. Fires, are you ready?
I believe my client's locked up on bond hearing, Judge. I was here earlier, we were waiting to see if the witnesses this case would appear.
A Whitehead?
Yes.
Okay. I guess so, so.
She said nobody checked in.
Isaiah Casey, Maria Sean Pearson. Isaiah Casey.
All right, where is Miss, Olson? I'm ready for it. Okay.
Yes.
And then I'll just,
He did. Yeah, I know.
Mr. File, Mr. Kodiak, you want to talk about Whitehaven? I'm gonna be calling Noble down in just a moment, because,
Okay, thank you, Judge.
Alright, let's talk about Whitehaven real quick while he's on his way down.
Even though this is sidebar, Governor.
Yeah.
We have a trial date March 20th. We want to get them out today. And this is the statement.
I notified the was the first to go out there last year as a master.
So you want what?
The perfect.
Oh,
Yeah.
All right. This, how many victims?
Two.
Two victims on South Bend. I didn't see it.
Well, apparently, we're still trying to figure this out. There's some videos that we can have, however, my understanding and everything that has been provided was not have a weapon that he's in charge for shooting two people.
So two people got shot?
Yeah,
Okay.
but my client apparently did not do it
Okay. How did your client?
because I think that the shooter got out of his car, so he drove to his home. My client is a dealer got into it.
And did you find a shot?
Yeah, he got shot. Apparently, from what I could gather, he got shot from the driver. The taxi was so far, he went through the car, hit the victim who was sitting in the driver's seat, went through the driver's door and hit the corner of the road.
So the victim was in the car?
Yeah, the victim, in this case, Mr. Christian got shot 7 times.
So who was it supposed to allegedly be?
Apparently, Mr. Webber and Mr. Pearson.
Oh, so two people were supposed to be selling drugs to victims. Victim gets in the car?
No. Victim was sitting in the car at the shell station, and somebody got out. And apparently, he had a 223 with the folks. He got shot in one corner, he got shot in the other, and went through the car.
So he's like standing in the car. He gets into a verbal altercation with victim number one. Someone with the defendant, so he projects himself into the verbal altercation. Fire. Two people sitting in the car, the bullet goes through the car and strike.
And apparently the police officers were looking for the shooter who all the information says it's 5354 lights being interested in the information of the various calls that day. That's correct, that's in
Fair enough.
You all agree? You use your code there? That's fine. I guess we would be moving question here, because we're not here to do any because it seems like it'd be important if you.
Well, you are explaining discovery.
Yeah.
Okay, perfect. You got discovery?
I got a lot of it, we've been going back and forth and trying to stuff, but maybe I don't know that she, if we both need to clarify before we. Did you sit?
This is the matter of State File versus Devon White, case number B2205786. Please close the door. Please close the door and have a seat. Mr. Whitehead is present in the courtroom with his attorney, Mr. Richard File, Ms. Jackie Sokoliak for the state of Ohio. This matter is set for a clear trial setting. We have a jury trial set March 20th, Mr. File. let me ask, you have Discovery and are things flowing with the Discovery Exchange?
I believe I have most of it. There are a couple of items that the state and I discussed, and we're trying to come to a resolution of some items that we believe would be material to this case. But I have reviewed all body cam, listened to the 911 calls, and reviewed all the motor vehicle recordings that have been provided. I just got a pack of stuff this week or actually today. I've reviewed it preliminarily this morning. I've discussed matters with regarding all this with my client in the state, and I think that we're moving in the right direction now as it relates to Discovery.
All right, thank you. Mr. Koliak, anything you want to add?
No, Your Honor, thank you.
All right. So I want to set this matter for a final pretrial conference. We can do that, Ms. Howard. Actually, he's looking for a date. The trial date is March 20th. I know you have a motion to reduce bond that is pending. It's filed January 5th. Has the state had an opportunity to comply with Marcy's law with regard to the victims?
I have, Your Honor.
All right. And are they present?
I called in the courtroom, and in the hallway, there is no response.
All right. Ms. Howard,
March 9th.
can you do March 9th at 9?
Right across next door, Judge, that's fine.
All right,
Judge
yes.
Branch, that'll work great.
March 9th for final pretrial conference. If you want something set before then, Mr. File, if there's a motion to suppress or some kind of evidentiary hearing you want to have, then please just file the appropriate motion and they'll deliver a hard copy to us and we'll put it on the calendar.
Thank you, Your Honor.
All right, so let's address the motion for bond. What do you want to say?
Judge, based on the motion that we filed, I understand the reasonableness of the bond at this point. However, Mr. Whitehead was severely injured as a result of this incident. My understanding is that even though that he's been charged as set forth in the indictment, all my information indicates that he did not possess a weapon whatsoever. In this case, he was actually shot by somebody who has not been charged, and I believe the police are still looking for the individual who possessed a weapon and did the shooting. He is not able to post much as a monetary amount, but we did set forth in the motion. He might be able to come up through his family and friends, possibly $15,000 as an anyway bond. He's also had an infection. I've reviewed some of the medical records while he's been there. He's been back and forth to University Hospital. He was actually arrested and detained as a result of checking himself into the hospital for the shooting. He got shot in the abdomen and in the leg. And it's would be prudent to further our defense in this case if Mr. Whitehead was available to meet with me. And he also has indicated to me that he would like to pursue additional medical care for his wounds. He says he does have CareSource insurance to accommodate those needs. So that's what we're asking for, Judge, at this point.
All right, well, where do we live?
He's going to be residing with his girlfriend here in Hamilton County. He's also got other contacts, and he doesn't really even have a record whatsoever that I can find.
All right. Is that where you lived before this happened? This discharge?
Yes, that's correct, Judge. He's nodding yes.
And where's that?
Can you tell the judge where you're living?
My charges?
No, where you're residing.
Oh, Wonder Hills with my girlfriend.
Where in all of this?
I don't know
You don't know the address?
no ma'am, but
Did you live there?
She here,
Did you live there
yes,
before this happened? And you don't know the address?
no ma'am.
She's here, Judge. His girlfriend's here. She can.
Okay, ma'am, can you step up?
Before you say anything, you can tell the judge your name, and tell her where you're residing.
Hi, what's your name?
Paige McClendon,
All right, hi. Where do you live?
299 East McMillan Street,
298
929 East McMillan Street.
929 East McMillan? I see. All right, and, was he living there before? All right,
She's here for you.
Yes,
all right, and so he can come back there?
yes,
Who else lives in the home?
my two daughters,
And how old are they?
4 and 3.
All right. Do you work outside the home?
Yes,
You have daycare for your children?
yes, he also helps me.
Is he their father?
No,
Well, he doesn't look like he's in a position to be helping take care of the kids. You realize that?
yes, ma'am.
Okay.
I work third shift, he's just there with them overnight.
How long did you know each other?
2 years.
Okay, well, with regard to the, motion to reduce bond, the state has complied with Marcy's law, the verse report. I'm gonna, grant the motion to reduce the bond, it's gonna be reduced to 20,000 at 10% with EMD GPS. And, we have a final pretrial conference set, and, if there's anything additional you wanna, add to the docket, just please let us know, we'll be happy to accommodate Mr. Bond.
Thank you for your, hearing our motion today, Your Honor. Thank you.
Thank you, Say.
No, you're
All right, thank you. Mr.
Good morning, Judge.
Good morning, Mr. Evans.
Good morning,
Are you ready? I have somebody who will wait on it. Mr. Nolan. I have a lot more to have to do. Mr. Nolan. All right, let's call Sweeten. This is the matter of State of Ohio versus Lamar Sweeten, case number B22036642. Mr. Joshua Evans, on behalf of Mr. Sweeten and Ms. Jackie Stapowiak for the State of Ohio, this is all for a status report.
Yeah.
And, Mr. Evans, I was informed that your client refused to promote today, didn't want to participate. Did you know that?
I did not know that.
All right, have you had a chance to talk to him?
Earlier in the week, we had a plan for tomorrow. I did not expect him to refuse to come over today.
Okay. Well, there's a motion to reduce the bond, and, the court doesn't have a copy, just got a copy today. Not have a motion to compel. See, the thing about how the system works around here, which I try to tell lawyers, I've been telling them this for 2 years. Please deliver a hard copy to the court when you file, not the day that the hearing is, when you file, because the court has to be prepared for it. The state has to be prepared for it. So when you just bring it to court, I don't do fly by night and I don't do raggedy. Okay? So, state, have you received a motion for a reduction of the bond, or reinstatement of the bond?
I have not, Your Honor. Mr. Lewis did text me on Friday on behalf of Mr. Evans indicating that the motion to compel the bond motion would be filed. I was aware of it, but I have not seen either one of those.
All right, well, has the state had an opportunity to comply with Marcy's law?
I actually have, Your Honor, the victim's mother was present at our January 5th final pretrial. I had conversations with her, and the prosecuting witness was present this morning, so I did have an opportunity to chat with her.
All right, excellent. So everybody knew about the motion to reinstate the bond except for the court, who has to make a decision.
Your Honor, this one we find court we can continue, so it's
Do you want me to continue it?
I will, Your Honor.
Okay,
And we also, at this time, the state is giving discovery, I will withdraw my motion from bail.
okay. So, oral request to withdraw your motion to compel is granted. Now, I'm happy to, continue this at your request, Mr. Evans, particularly since your client refuses to come over. But I also am happy to go ahead and, address it if you want to. So what, I'll leave it up to you.
Your Honor, I would ask for continuance.
Okay. So, our next date looks like, well, we don't have next dates. We need to set a trial date and a final pretrial conference. And, so let's, this case has been pending a little bit of time. Mr. Evans, how much time do you think you need to get this case ready for trial?
30 days, Your Honor.
Okay. State, what about you?
That would be fine, Your Honor.
Okay, so this is already the end of January, so this, will be the beginning of March,
We have
or the end of February? We'll
March is fine, Your Honor.
We'll throw some dates out and you let us know.
We could do, March 6th.
March sixth? Is that what you said?
Yes, ma'am.
March sixth, does that work?
That works, Your Honor.
All right, let's do March sixth.
Your Honor, may I please support?
Yes?
My apologies for speaking out of turn. This court is where Mr. Evans is mentor, and he is checking with me because he's serving as co-counsel on the trial, so just want to make sure the date didn't conflict, so that's why he keeps coming back to the table. My apologies.
Okay. Thank you, Sue Lewis. So March sixth at 10, it works for your calendar?
That works.
All right, and, what about final pretrial conference, Ms. Howard?
Final pretrial conference, February 23rd.
Does that work for you, Mr. Evans, February 23rd?
That works.
All right, so February 23rd, we'll do a final pretrial conference at 9 a.m. Now, we do need to, continue for the bond hearing. And I would imagine you want that sooner than later.
Yes, Your Honor.
All right, so Ms. Howard, what do we have? Are you talking about sooner, like later on this week? Or
It can be if the court's if available.
Well, you know what? Do it, maybe Mr. Seaton will, appear. So we have 2 Zoom days this week. We have one Wednesday and one Thursday. And, we can work with the jail to have Mr. Seaton stay at the jail and here. And then I know you have to be Zoom, so, and if the alleged victim wants to appear by Zoom, that would be, convenient. So which day you want to do, Wednesday or Thursday?
Thursday's fine.
Thursday, does that work for you, Ms. Dakota?
It does, Your Honor.
Okay, so let's do Thursday. What day is that? 26th, all right. So we'll do the bond hearing on the 26th at 9 via Zoom, okay?
Thank you, Judge.
All right, so we have our dates. Time related to the trial?
Yes, ma'am.
All right, anything from the state?
No, Your Honor.
All right, do you have discovery?
I do, I believe I have everything.
All right, excellent. All right, thank you very much.
Thank you.
Judge, can we approach briefly?
Sure. Mr. Knapp is here, wait a minute, Ms. Wallace, hold on. Yes.
The decommission expressed our Not the space. So they are in order to facilitate efficiency by yeah, I was gonna say, especially you have a general admission. Yes.
Did everybody please make sure your phones are cut off? Look away, make sure your mask is on your face, cover your mouth.
Okay, over here.
Thank you.
I have that from my officers. Yeah, but let's do that. Get your numbers.
Thank you.
Yes.
I missed the touch on, I think that it's a wrap up.
All right.
All right.
So my only guess is out of town for much time. Besides that.
I have one detective out until 2/3. She has been service on 2/8. And then the other detective hasn't been service in February 8th. I would expect him to be back. So we can about the second week of February. I think so. I will tell you that I have. I have two other trials set and one to report.
I'm not a fan of 6 years. I could do the foot, we get the foot set. I don't blame you. That's the third.
I guess I could do that there.
Yes, the crowd, the resident of the church. Yes, ma'am. We have 5-2 trial.
Probation violation to the child.
Probation.
So we just put that in the,
Madam Pretrial Conference.
March 23rd.
I know you can.
I'll be back.
Yeah, that's it.
That's fine.
Nine. And then this island was, it's put on our, February, that one was the status. We did that very 16.
Status.
Yeah. Everything is,
16, right?
yes, February 16.
I think I have a.
The status February 16. There was an active trial.
Are you guys waiting time?
Like you do that. Oh, there.
Yes, we will. We will review it. Okay.
February 15th,
16.
16th for the final pretrial?
Yes.
No, that's status.
Status, yes. And then the 23rd for the final pretrial, and then the trial date is set April 3rd,
Yes.
March 23rd for the final pretrial.
Yes.
Excellent.
And, we'll put the public trial. Okay. Council. Mr. Knapp, do you want to see me and Mr. Kodak real quick before I start this hearing on Noel? Okay.
Can I get back this way?
Yes, ma'am.
Okay, thank you.
Mr. Knapp, Mr. Kodak.
Hey, how you guys doing?
She was here. She was here. Okay, I'm gonna need to find out what's going on. They can come back. Mr. Knapp, what we doing?
Judge, we have Mr. Cannon.
Oh, okay, well, I gotta get this piece of, no, it's not gonna take long. It could possibly. I gotta get this one. Business laws.
She came to me with a plea offer. I need a second to talk to the victim, and that will likely be a plea as well.
Okay, we'll just start on that one.
I talked to that later today or different day.
Yeah, I'm thinking,
Judge, I'll tell you, Mr. Cannon, becomes a problem with Christmas. He has a video conference at noon with, I guess, his girlfriend and his other children, so. Yes, well, either today or I just want to make sure he makes his conference, video conference with the jail.
Oh.
So if we want to continue to a different day, he said he's mid, so that would work for him.
okay,
Yes, sir. Yeah.
can you do, please, one,
Yes. Well, if they hold him up there, he will miss his conference.
listen, that?
What?
I wanted to include on campus at one.
Okay.
But I want to go back, because he has a conference with the.
Mother of the children. He had trouble on Friday. His girlfriend was there.
Uh-huh.
So he's had a very good conference with her, and
Okay.
so someone is keeping locked up.
So you mean tell me he needs to go back and come back?
Yeah, so we have to go back over.
Come back, okay, you come back at one?
Okay.
All right, we'll do it one chart, thank you. And Mr. Foley, I just keep me abreast of what's going on, what's going on with squalls, because if we can do that too, then we'll do both things. Okay, thank you. All right. This is a matter of State of Ohio versus Wesley Noble. Case numbers B 22-02445 and B 2004210B. This matter is set for a jury trial today and probation violation hearing. However, we still have to continue the motion to suppress hearing. And Mr. Knowles present in court with his attorneys, Mr. Herb Haas and Mr. Connor Riley and Ms. Polson for the state of Ohio. So, counsel, I know we're going to continue on the motion to suppress. And, but we do need a trial date, final pre-trial conference date, and a status. And I've worked with you all to get that. Mr. Noble, your trial date will be April 3rd at 10 a.m. It's a firm date, it will happen. The final pre-trial conference will be March 23rd, 2023 at 9 a.m. And then we're going to do a status next month, February 16th. I'm going to continue your probation violation to April 3rd only. Because your attorneys have indicated they don't want to resolve that until the trial. So, counsel, are those dates agreeable to you, and did your client waive time?
Yes, and yes, Your Honor.
All right, thank you very much. And Mr. Noble, is that agreeable to you?
Yes, Your Honor.
All right. All right, so we're gonna have this motion suppressed and continue in progress, and then I'm gonna have Mr. Noble and counsel sit at counsel's table so that we can go forward. Is there anything you want to put on the record before we continue, resume the motion suppress?
Yes, Judge, you were going to admonish people that you.
I'm gonna do that once you all sit down.
That's all I read.
Okay,
Nothing further.
all right. Anything on behalf of the state of Ohio?
Judge, I would just ask for the same admonishment.
Yeah.
Please turn your phones off.
Yes, sorry. On Ms. Wallace's case, there will be a page I help her.
Yes, thank you so much. And then if you're, I think that'll be getting to the ones, All right, this matter is continued in progress on the defense's motion to suppress the evidence of identification. And we are, getting ready to resume with the state. Is it the state calling witnesses or is it the defense?
The state has rested.
All right, the defense will be calling witnesses. But before we do that, can you have a seat for a second? I want to admonish everyone in this courtroom that it has come to my attention that some comments and even perhaps some aggressive or assertive commentary has been given to people that you think may be witnesses or involved in this case in some way. Let me be very clear that threatening a witness is a felony offense. One that this court does not, will not tolerate or take lightly if you are charged and convicted. So let me just say, just to everyone as a blanket, because you may be sitting there thinking, I didn't do anything, I didn't say anything, well, someone has. So let me be real clear. No statements, no threats, no jeering, no anything to anyone involved in this case. And if you think we won't know, please understand that there are cameras and audio all around this courthouse, inside and outside. So let this be a friendly warning. Just don't do it. All right? All right.
Judge, may I ask that your admonishment extends beyond the walls of
Today.
the courthouse and beyond today until this matter is completely resolved and frankly after?
All right, well, this admonishment is in effect while this case is pending. While this case is pending, that's the admonishment. And anyone who is charged after this moment with threatening a witness or anyone else involved in this case will be dealt with. All right, so let's just cut it off here. All right, all right. So the state is arrested, Mr. Right.
Thank you, Your Honor. At this point, the defense calls Samantha Ritchie.
All right.
And you can go back together, Judge, if that's all right.
All right.
You're gonna get her? Okay, thank you.
Mr. Bryan,
Yes, Your Honor.
you can make a favor,
Absolutely.
just to make sure this microphone is on already. You can just-
My copy will be ready.
Can you make sure this microphone is on, just keep, is it switch to, well, switch to. Is it on? No, you turn it off. Okay, thank you. All right, ma'am, if you wouldn't mind just coming, walking right around here to the witness stand, and then once you are there, if you wouldn't mind raising your right hand and facing the court. Thank you.
You solemnly swear the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, ma'am, once you're comfortable, this microphone, it moves, so you can just pull it toward you, that's perfect. All right, thank you very much.
Thank you. Good morning, ma'am. Could you say and spell your name for the court reporter?
Samantha Ritchie, SAMANTHA
Ms. Ritchie, were you present at a shooting on April 20th of last year?
I was.
Later on, did you perform a witness identification process at the police station?
I did.
Your Honor, at this point, I would ask for the allowance to use meeting questions during this examination pursuant to Ohio Rule of Evidence 611C.
State,
Well, Judge, I would object. I don't know what the reason is that he would be allowed to use leading questions, but I would also note that this is a motion to suppress. And in the court's discretion that, the rules of evidence can be suspended and, Mr. Riley could use limited leading questions, of course, with the court's permission and discretion.
well, I don't have any, I don't hear a basis for leading questions at this point.
I can reiterate the issue, Your Honor.
All right, thank you.
So, Mr. Ritchie testified that you did witness a shooting on April 1.
Yeah.
Could you tell us, we're trying to determine what your perspective was that day. Could you tell us what you observed on April 1?
Pardon me, Judge, I'm gonna object at this point because it's my understanding that we are here for a motion to suppress, and I would ask that the testimony be limited as to Ms. Davis's experience in the photo lineup, because the issue before the court at this point is whether or not the photo lineups should be admissible in evidence in trial. This isn't a preview to Ms. Davis's testimony in trial.
All right, thank you.
Your Honor, Ms. Ritchie's perspective, ability to identify, make any identifications is relevant to whether, and on point for this motion. So her perspective, that these motions, time of day, lighting, all these things are relevant pursuant to motion expressed.
If I may respond, Judge?
Briefly,
All of those things are relevant as to whether or not Ms. Ritchie made an appropriate identification. They are not relevant as to whether or not the motion to suppress was conducted in an appropriate manner and should therefore be allowed to be entered into evidence.
I
So the
agree.
issue. Okay,
And so the objection is sustained, and your questions are limited to your motion to suppress the evidence of identification on the issue of unnecessarily being suggestive of Mr. Noble's guilt.
Your Honor, just so I understand what you're ruling on that objection, you want all questions limited to the interview that occurred, the photo identification that occurred on April 30th.
I want your questions limited to the issue of whether the identification was unnecessarily suggestive. Now, whatever you want to ask in that arena is absolutely permissible.
Understood. Ms. Ritchie, were you at some point presented photo identification labs?
Yeah.
Do you remember that?
Yeah.
Okay. About what timeline did it occur following the shooting of the US?
I don't remember, it was the other day,
Okay. Maybe 10 days after, sound right?
maybe not positive, how many days after.
Did you give different statements on different days? Were you asked about this on different days by the detectives in this case?
No, I was asked once.
You were only asked about what happened on April 20th, one time by the detectives?
Yes.
Did you speak to the detectives on the day of the shooting?
I did.
And where was that?
At their office.
At their office? We believe that that's the same day that you were presented these photo lineups?
No.
Okay. So that was on a separate day later?
Yes.
Okay. So on that second time, when you were shown those photo lineups, is that about 10 days after the shooting?
Probably.
Something like that?
It was after, I know that,
It was
yeah.
after the shooting, okay. And you were presented, tell us how that process worked, what was shown to you?
I was taken into a room
in a folder given to me on the table. They told me to open it up, there would be 10 pictures inside of the folder. And then I would look at each one, take my time, and choose the person that I thought I would need to look.
Okay. And do you remember that you were shown 2 different sets of photo IDs?
I would.
Okay. And do you remember on that first set you were shown, how that process went?
I do and I don't. I mean, I went through them, yeah.
Okay, you went through the photos.
Yes.
And in that first set you were shown, do you remember making any kind of an identification?
I believe I chose one I wrote first, but
Okay. And you were asked, to what degree of certainty could you identify this person?
yes,
And you said you were 70% sure.
yes,
So at that point, you had made some degree of identification in that first packet of photos.
yes.
Now, based on what you had told the detectives about what happened that day, you were trying to identify one person, correct?
Yes.
And this is the person wearing all black, correct?
I didn't say whether they was.
Okay. You were trying to identify one person.
Yes.
And at that point, you made some degree of identification in that first packet.
Yes.
And then after you made that identification, you were shown a second packet of photos, correct?
Yes.
Okay. And this was after you made your previous identification.
Yes.
All right. Do you remember if you made any identifications in that second packet?
I believe so. I honestly don't know if we can both out the cursors and I really don't remember, but I know I took 2 pictures.
Okay. When you say them both out, who are you talking about?
I took a picture of somebody and then I took a picture of the defendant.
Okay. That's that other somebody you picked out.
I believe that was the first one that I had picked out. And I told him I wasn't positive that I need to look at the other pictures, because there was a lot of resemblance and it kind of looked like him, but I wasn't positive. He said, okay, we'll put it to the side and we'll go past that.
Okay. After you made that first identification, did that prevent you from correctly identifying someone after that?
Objection.
I'll withdraw the question, all right?
All right, withdraw.
After you made an identification, did you feel like locked into that in any way? That I picked that guy out?
I mean, I picked 2 pictures out and when I seen the defendant, I knew it was him.
I believe you gave a certainty level of 70%, correct?
I believe on one of them, yeah.
Okay. Your testimony today, you picked out 2 different people.
Yep.
Okay. And that one was 70%? Are you saying you positively identified somebody else after that?
No, I chose 2 people. I don't know like what percentage I found one at and what I found the other, but I know that one guy found one picture, I know who it is.
Your Honor, could I have one more?
Sure.
Judge, I think that there are some exhibits that are already in evidence in this case. Would it be possible that we can use, I think Mr. Riley would want to enter duplicative exhibits into evidence. Would it be possible just to use the ones that are already in evidence in this case for clarity's sake?
Okay. For purposes of this hearing, can we just go ahead and use those and perhaps, if they are ones that have been admitted, we don't have to be, pushes with our evidence. For purposes, because we did, she has to go with it.
Yes.
All right, so go ahead.
Thank you. May I approach the witness?
Sure.
What are you marking those? I can't remember.
Defense Exhibit A, Your Honor.
Yes.
And which one was that? What time was it?
1425.
Is it the back and the front?
Yes.
All right, can you guys talk off the record and not on the record?
Yes, Your Honor.
Thank you.
Ms. Ritchie, I handed you what I marked Defense Exhibit A. Could you tell us what that is?
He says information to provide, I would inside the line administrator.
And could you, at the bottom of that, does it have your name on it?
Yes.
Okay. And at the very bottom left, it has a location. Could you read that?
801 Main Street, Pittsburgh.
Okay. And that's dated April 30th at 14:25, right?
Yes.
Okay. Could you turn that over? And the bottom portion of that, it has a list of 6 numbers. Is that right?
Yes.
Okay. And those all have no next to them, correct?
Yes.
I'm going to trade you what I marked Defense Exhibit B. Is that the same kind of form?
Yes.
As Defense Exhibit A?
Yes.
Does it have your name down the bottom of it?
Yes.
Say 801 Lane Street?
Yes.
And does that one, what time does that say?
That says 14:18 hours.
So this would occur before 14:25, right?
Yes.
Okay, so this is the first packet that you did.
Yes.
Could you flip that one over? Does that have those same 6 numbers?
Yes.
And do those all say no, or is that one different?
No, this one's different.
What does this one say?
This one says 7% sure will quit.
On what number?
On number 6 with my signature.
Okay. May I first?
Yes.
So, Ms. Ritchie, after seeing these documents, do you now remember that on the first go around, you made 70% identification? Is that yes?
Yes.
Okay. And then you were shown a second packet of photos,
Yes.
and that one had all notes, you had no identification in that second packet.
Yes.
So, looking back on that, I know it was a while ago, at this point, do you remember identifying one person in those 2 packets?
Yes.
And that it was 70% certainty, correct?
Yes.
Okay. So now going back to my earlier line of questioning, after you were shown the first packet of photos and you made that some degree of an identification, right? 70% sure. You were then shown a second packet of 6 photos.
Yes.
At that point, you had already made an identification of some degree.
Yes.
Did that make you feel that you were maybe locked into that identification when you were shown that second packet? You did with the,
I'm sorry, answer the question.
oh, part of the answer. You had already made an identification, right? And you were trying to identify one person.
Right.
Having already made an identification, did that prevent you or make you feel like I already picked out somebody, I should have picked somebody else out of this line?
Well, no, I still looked in the lineup just to make sure that I was positive about her.
And where you left it was 70% safe. Round back just one more time.
Sure.
Thank you very much, Mr. Keith. You're all right, no further questions.
All right, thank you very much. Cross examine.
Hey, Ms. Ritchie, you need an okay? Okay, do you need anything with water or anything, or are you okay? You're okay? All right, just a couple of questions about your ID. Okay. Have you ever done a photo lineup before? No. Okay. Did you read the Cincinnati Police Department's policy on how to do a photo lineup? No. Okay, so you don't know what the rules are for doing a photo lineup? No, I did what he told me. He read a paper to me and then told me to look at each one carefully. If I had any doubt in my mind, or if I need to go back to somebody to put it to the top. Okay, so, I'm going to ask you actually to look at either Defense Exhibit A or Defense Exhibit B. Would you agree with me that this is the same form? This is the same form?
Yes, you're right, the same form.
Okay, is this what he read to you, this whole, all these rules here?
Yes, I believe so, he had the paper, he read it to me,
Okay, so who filled out all this other stuff, name of witness, doing lineup, is that your handwriting or police officers?
No, the only thing writing on the paper is my name and my signature, the rest of the writing is not mine.
Okay, is that the top line at the bottom on the left-hand side, your signature, where it says signature of witness doing lineup?
Yeah.
Okay, same thing on Defense Exhibit B?
Yes.
Okay. And both times, did he read the directions to you and completely start over, telling you how to do lineup?
I don't recall.
You don't recall. Okay, that's totally fine. Thank you for telling me you don't remember. Okay. When you looked at these lineups, were you looking for one person or two different people in the lineups?
I was looking for 2 people, but I only witnessed one.
Okay, you only saw one person?
Yes.
Okay. Do you see that person in the courtroom today? Yes. Can you please indicate where he is sitting and what he is wearing?
And 1, 2, and budget.
Okay, at the defense table? Yes. Judge, may the record reflect identification of the defendant as the person that Ms. Ritchie picked out of the lineup.
Any objection?
Identification of the person she picked out of the lineup. No, I have no objection to that.
All right, okay, so,
Okay, so, and is he the person that you picked out of the lineup in the first lineup?
Yes.
Okay. And then in the second lineup, were you looking for a different person?
Yes.
And you said you did not.
I never witnessed another person talk and give them another picture.
Okay, so you saw one person there and you picked the person that you saw?
Yes.
Would it be fair to say that you are not able to speak on whether or not this lineup was conducted correctly?
No.
Okay. Did you feel pressure into choosing one person or another?
No.
Okay. Did you feel like when you picked no one out of the lineup, did you feel like the police officer was disappointed?
No.
Okay. When you picked someone out of the lineup, did you feel like he was happy or that he gave you some indication of affirming your decision?
No.
Okay. Did you feel like the police officer showing you this lineup was completely unbiased as to who you picked out?
What do you mean?
He didn't care who you picked out, if you picked
Oh,
out.
no,
He didn't care?
No.
Okay. Judge, I have no further questions at this time for this witness.
All right, any brother?
No, Your Honor, thank you.
All right, thank you very much. You may step down now. And my bailiff will take you back this way. All right, your next witness.
The defense calls Elizabeth Miller.
All right. Ma'am, if you would mind standing and facing the rear, right hand up.
Please solemnly swear to testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth, so help you God.
Good morning, Ms. Miller. Could you say and spell your first and last name for the court? Thank you, Ms. Miller.
All right, I'm gonna need everyone to keep their voices up because I'm struggling to hear, okay? Thank you. And the microphone, ready to breathe this long. Thank you.
Ms. Miller, did you witness a shooting on April 20th of last year? You did? Okay. And did you ever talk to the police about that shooting? Did you talk to them on multiple occasions after the shooting?
One time,
One time.
not including the same exact day it happened.
So you talked to the police on April 20th, and then about a month later, you remember going to their station, the police station? And was it at that station that you were shown a photo of?
Yes,
Your Honor, may I approach?
Yes.
Ms. Miller, I just handed you what I marked as Defense Exhibit C. You go back to that front page for me. At the bottom of it, it has some information handwritten in it. Does it have your name in that?
it does,
And does it have a location?
it does.
What's that location?
801 Main Street,
And then over to the right, it has date and time. Could you read those out?
May 18th, 2022, at 2:15 p.m.
Thank you very much. Does that date and time sound right about when you went in and talked to the police? And because I think you could remember doing a photo lineup series.
Yes,
Before you did that photo lineup series, you spoke to two different detectives.
yes,
And then a third totally different officer came in and he did the photo lineups, correct?
yes,
When you were talking to the detectives, do you remember telling them that you would be able to identify the shooter?
I already said that if I see a photo that looks familiar, I might be able to.
Okay, and you saw his face?
Yes.
Right, okay. And then you were, the third officer came in, he's the one who showed you the photos, right?
Correct.
Could you explain how that process worked?
I believe there was 8 to 10 photos, not sure which one. As I opened them up, they were blank, and I had to flip them over. And each one had a picture, except for the last two, they were blank.
Okay. So the one with photos, and it was your job to determine if one of these people was
Yes,
the person you were trying to identify, right? You're trying to identify one person?
yes,
And as these photos, as you open them and turn them over and look at them, you would tell the officer what you felt about that one,
correct,
how close to the person.
correct,
And of those six, you didn't identify any of those six as the shooter, correct?
I don't think so.
I got one more turn.
Sir.
Thank you very much. Your Honor, I have no further questions for this witness.
All right, thank you. Any cross-examination?
Thank you, Judge.
Elizabeth, how are you doing?
I'm good, how are you?
Okay. Do you need anything? You need water? You okay?
No.
Okay. Before you went in to do the photo run, did you familiarize yourself with the Cincinnati Police Department policies and procedures on how to do photo runs?
No, I just read a piece of paper that was given to me before.
Okay, did the officer read it to you too?
Yes,
Okay. So you just read those, so you don't know how to give a photo run?
correct,
You have no idea if the officer gave you an appropriate photo line or not?
correct.
Okay.
I don't do that.
Okay. So you have no idea if you follow the rules and policies and procedures?
Correct,
And you wouldn't be able to testify about that at all?
I don't believe so.
Okay. Are you, when you did the photo lineup, did you feel like the officer was disappointed and didn't bring anybody out?
No,
Did you feel like he was happy and didn't bring anybody out?
no,
Did you feel like he had any stake in whether you chose someone or didn't choose someone or who you chose at all?
no,
Did you recognize anyone in the photo?
not as people I know.
Not as people you knew?
No.
Okay. As people who were there at the
People
time?
that look familiar,
People who look familiar?
people that may have looked familiar.
Okay, you did see people who maybe look familiar. Familiar as to whether or not they were there at the time of the, when Mr. Diaz got shot?
Yes.
Okay. Did you see anyone in that lineup who looked familiar?
No, I had to have some single lenses, but.
I'm sorry.
Okay.
Can you speak up just because you're fading out?
You didn't see anyone who looked familiar?
Correct.
Okay. Judge, at this point, I don't have any further questions for Ms. Collar.
All right, thank you very much.
Very briefly, Judge, good afternoon. My name is Mr. Ross. Have we ever spoken?
No.
Okay.
Judge, I'm gonna object, I think Mr. Riley has to.
I was thinking what to say, what are you doing? Council, can I see you to start for a second? Before you start? Sure.
Ms. Miller, just a few more questions. Okay. Ms. Polson just asked you that you were trying to, find someone in these photos who looked familiar.
Correct.
What you were trying to do was to identify a shooter on
Objection,
April
meeting.
20th. This door was open.
Hold on. Objections to the meeting, so,
Your Honor, I'll rephrase the question.
all right, to rephrase.
Thank you. What was the point, from your perspective, what you were trying to do when you were showing these photos?
Judge, I'm also gonna object because I don't think that again, this motion is purely for the court to decide whether or not the photo lineup was administered properly.
I understand, overruled. Ma'am, you may answer.
I'm not sure if I finished it, I'll repeat it for you. When you were going through these photos, what were you trying to do when you were looking at the photos?
I was seeing if anything was familiar as to what happened that day. If anybody's face looked like it might have been familiar.
Familiar in regards to what?
Based on the way that happened.
With someone you saw at a coffee shop that day, or?
No.
So in particular, what?
In particular to the day that happened.
Were you trying to find if someone, if one of these photos was a particular person?
No, not someone in particular. I just wanted to see if any of the faces were familiar as far as the person that did the shooting, I guess.
Look familiar?
As far as the people that were there,
Okay.
to see if I could see anything that familiarized myself with
And that you said as the person who did it, or something of that degree?
that. Yes.
Okay. Your Honor, I have no further questions. Thank you very much.
All right. Now you may sit down. This is how we will take it. All right, call your next witness.
Defense Rest.
All right. State, do you have any additional, any rebuttal?
I have no rebuttal with this judge.
All right. Are you ready for argument?
I have a brief argument to make before closing argument, if the court will permit it.
A brief argument before closing
Yes, Judge.
with regard to,
I would ask that the court strike the testimony of both Samantha Ritchie and Elizabeth Miller for the purposes of this hearing. Both of them said that they are not able to speak as to whether or not the lineup was administered properly. They both said that they were not familiar with how you administer the lineup. And I would ask that the court consider striking their entire testimony from the record, because they literally can't add anything for the court's decision as to whether or not the lineup is properly administered.
all right, I'll let the defense briefly respond if you want, or if you just submit.
Your Honor, I'll just sit on the.
All right, denied. All right, we ready for closing? Or not closing, but your final arguments?
Yes.
All right, so defense's motion.
Yes. Your Honor, very briefly, I will submit on my motion as far as Elizabeth Miller's identifications, two identifications in question and subject to the motion to suppress. Very briefly, just to supplement my arguments made in my motion for the identification Samantha Ritchie made, pursuant to Detective Smith's testimony at the first day of this motion. Ms. Smith testified that there were two suspects in this case, which is why Ms. Ritchie has shown two different patterns, one with one suspect, one with another suspect. Your Honor, I would just make the argument that it is suggestive to have a witness go through the entire packet, make some degree of identification, in this case, a degree of 70% accuracy, make that identification, have that written down by the officer, and then show a whole second packet of photos when they've already made that identification to the officer. That would be my only supplementation to participate in my motion also.
All right, thank you very much. Stacey?
Judge, this is when the court decides whether or not to suppress a lineup identification, it is a two-step process. The first question the court must ask is there any evidence that would show that this identification was presented in a suggestive manner? Here, the defense has failed to show any evidence that these lineups were shown in any kind of suggestive manner. It's very clear that they were presented to the witnesses in accordance with the Ohio Revised Code, Cincinnati Police Department's policies and procedures. And in fact, the witnesses themselves, both Elizabeth Miller and Samantha Ritchie, said that they did not feel any pressure from the officer. They felt like he was completely indifferent as to who they chose in the lineup and whether they chose anyone at all. So clearly, these lineups were not presented in any kind of suggestive manner. I would ask that the court wholly overrule the motion to suppress. And I would note that on Mr. Riley's point in his argument earlier, he said that Ms. Ritchie was shown two different lineups. So she was shown one lineup where she picks out the defendant, and then she was shown another lineup. She very clearly testified that she was looking for two different people. So there's no reason to suppress any of these lineups in this case. And I would submit on that. Thank you, Judge.
All right, you're submitting, defense is submitting?
Yes, sir.
All right, thank you very much. So before this hearing today, we resumed from a previous day, which was December 14th, 2022. Before this hearing this morning, the court had an opportunity to review my notes with regard to the testimony of Detective, I think it's Tyus. Is that how you pronounce his name?
Yes, it is.
CPD criminalist Brad Smith and retired CPD officer John Horn. And so the court was able to review that evidence and the law with regard to this motion to suppress just before the court took the bench. Additionally, the court has just heard the testimony of two witnesses called by the defense with regard to its motion to suppress. The court has to, is guided by the Supreme Court case of Neal v. Biggers. It's the Supreme Court of the United States. And in Neal, and under Neal, there's a two-pronged test as the state has indicated. The first question is whether the identification procedure was unnecessarily suggestive. And then, if you get past that prong, then you have to determine whether under all the circumstances, the identification was reliable. And that is whether the suggested procedures created a very substantial likelihood of irreparable misidentification. Based on the evidence in this two-day hearing, the court finds that the defense has failed to, on the first prong, and that is whether the identification procedure was unnecessarily suggestive. The court finds, based on the evidence, that it was not. And so the motion to suppress is hereby denied. All right, so we have a trial date, a final pretrial conference date, and a status for status is set next month. And the motion, the probation violation will be continued to the trial date. Is there anything else we need to do today?
Not on the fence, then, Your Honor.
Not from the state, thank you, Judge.
All right, the court will put on the written entry denying the motion suppressed, and then we will reconvene on the status, February 16th, 2023 at 9 a.m. Thank you, everyone. Thank you.
Thank you, Judge.
Yeah. Yes, ma'am. Am I gonna want this here?
Okay. Do you want me to Nope, I got one, and I'll just email it to you, okay? Thank you.